contingent on the sovereign recognizing those. So the sovereign could always take them away. But it was in 1984, 85, the Guerin decision, where the Supreme Court of Canada actually finally accepted that there was this notion of inherent rights, which is like God-given rights, right? If you read natural law theory of our individual liberal rights that we have in our Western democracies, it's a God-given right that a sovereign shouldn't be able to harm individuals. There's this natural law kind of theory. It's similar to that. It's God-given rights. The Creator recognized or set these people, and maybe it's the Cree in this territory. That's our belief. It's a God-given right that we are here on this territory. And that's the inherent rights theory was accepted by the Supreme Court. From the Royal Proclamation and this contingent rights theory, the first big Aboriginal rights case, where the Supreme Court of Canada actually recognized such a notion as Aboriginal rights in Canada, because there was a lot of debate. There were these sort of ideas that, well, we have a moral obligation, we did enter treaties with them, we should honor that, but the federal government often didn't. As soon as a treaty was signed, they passed the Migratory Birds Act, right? You can hunt, you can trap, you can do all that, but they set these laws in place, which criminalized the activity that the traditional economy became criminalized really overnight, or over a series of these policies that were passed in laws. But the Calder decision in 1973 was the first time the Supreme Court actually considered what Aboriginal title and rights really were. There was a panel of 7 judges. 3 of them, actually 6 of them, said there is such a notion as Aboriginal rights. 3 of them said there's such a notion, but those rights are extinguished. In British Columbia, because Calder was Anishka, that's northern British Columbia, up past Terrace area, there past Prince Rupert, up in that area. So these 3 judges said there is such a notion as Aboriginal rights, but those rights are extinguished because the Crown has been legislating over these areas. You no longer have those rights. They're extinguished. And the other 3 judges said there is such a notion as Aboriginal rights, and they still exist. So your math is 3 and 3. Where's the other one? The 7th one decided against Anishka on a technicality. It was a technicality. But now all of a sudden, in law, our Supreme Court of Canada has said there is such a notion as Aboriginal rights and title that have to be dealt with. So following that, 1974, the federal government developed the comprehensive claims policy, which they entered into agreements with, especially in the north, mostly in the north, but places that hadn't entered treaties yet. And then they also had a specific claims policy where lands were illegally surrendered on reserves, or sometimes people didn't get a reserve. So anyway, that was also set up at the time. So a big change, a complete huge tremor shift in legal thinking in Canada when that decision happened. And then there was a series of cases, but the next big one is, the next big moment is the Constitution Act 1982, where Section 35, existing Aboriginal and treaty rights are hereby recognized and affirmed. So that was put into the Constitution. At the same time, we all got our individual charter rights as Canadians here at the same time. There's a debate about whether or not Section 35 is really in the charter or not, but it's kind of right there, right there. Right past Section 25. But, so from that point on, there wasn't a case where the Supreme Court really looked at what does Section 35 mean anyway, until 1990 and the Sparrow decision, a huge decision. And so the Sparrow decision was a fishing case in British Columbia, Musqueam First Nation. Ron Sparrow was fishing with a net with the, I don't know what you call that, the little hole was too small, so it's catching more fish than I guess the regulators wanted. The Supreme Court of Canada looked at the Royal Proclamation, the Rupert's Land Transfer, treaties. They looked at and the literature and the legal theory and the arguments and tried to say, why did the governments, the federal government, all the provincial governments agreeing to have Section 35 rights in the Constitution anyway? And so they did that analysis and they said, well, because of this prior existing sovereignties, recognizing these existing rights, they have to mean something. So they did that analysis and they came up with the Sparrow decision. Now, if any of you have taken any kind of study of, say, criminology or something, you may have heard of the Oakes test, where our individual rights are guaranteed that the state can't do legislation and action that impinges our Charter of Rights. However, there are times when they need to, right? Our rights are not absolute. It's the same, they use that same kind of analysis in the Sparrow case. So we have existing Aboriginal treaty rights, but there are times that the court is saying when the government's regulation and actions can override those rights. And it has to be a minimal type of infringement, at least to some extent. So that's what the Sparrow test is all about. The government's objective with regulation of fishing is to preserve the resource so people can continue to harvest fish, right? Including the indigenous people. If all the fish were gone, we wouldn't be able to practice our Aboriginal right anymore, right? So it makes sense. So that's what the court is saying. There's this objective to deal with that problem. However, the court also has to justify why it did that. And the other thing that happened in the Guerin case, let me just step back some. I'm talking about the Sparrow case, but I want to frame one other thing in here. It's called the honor of the Crown and the fiduciary duty. In the Guerin case, that was a case in British Columbia again, in Vancouver. The Musqueam First Nation had a golf course. So this dealt with First Nations property and the uneven relationship between the government and its relationship through Section 91, 24, and the Indian Act, and the power it has over Indigenous people, well, First Nations people, that unequal relationship. You guys, a lot of you probably know the notion of what a trustee is. If you're a trustee, you need to handle the money or the resources that you're a trustee of for the best interests of whoever that beneficiary is. It's a very similar idea of what fiduciary duty is all about. So the Guerin case, there was an extension of this lease for a golf course, and a negotiator for the First Nations and the golf course negotiated, and the government was there, the federal government on behalf of the First Nations. The First Nations did not see that lease agreement, that new lease agreement, for 10 years. They weren't even showing it for 10 years. And again, they were arguing the same thing. This fiduciary duty is kind of, maybe it's kind of moral to sort of, and ethical to do that, but it's not a legal obligation. And the court slapped them upside the head and said, yes, there is such a legal duty, and you also have to pay $10 million in compensation for that. Now that's dealing with property. In the Sparrow case, that duty, that fiduciary duty, broadened not just when the federal government is handling my reserve lands or my property or my oil and gas or whatever. It's also the relationship. They broadened the fiduciary duty to the relationship between Indigenous people and the Crown. The Crown has to behave and make a lot of its decisions in the best interests of those people. That is the First Nation, the Indigenous people. So it really was a great case for broadening that relationship. Now, how much they live up to that is all debatable, but it certainly changed the way they had to behave. So getting back to the Sparrow decision, the Sparrow test, because our rights are not absolute, if the Crown passes a law or legislation that infringes that right, they have to prove that it's justifiable. It's a justifiable infringement. So there's an analysis. They have to